Excise duty. So firstly, we should know the meaning of excise duty. Central excise duty is an indirect tax levied on those goods which are manufactured in India and are meant for home consumption. The taxable event is manufacture, and the liability of central excise duty arises as soon as the goods are manufactured. It is a tax on manufacturing which is paid by a manufacturer who passes its incidence on to the customers. Central excise revenue is the biggest single source of revenue for the government of India. The union government tries to achieve different socio-economic objectives by making suitable adjustments in the scope and quantum of levy of central excise duty. The scheme of central excise levy is suitably adapted and modified to serve different purposes of price control, sufficient supply of essential commodities, industrial growth, promotion of small-scale industries, and like authority for collecting the central excise duty. Section 3 of the Central Excises and Salt Act 1944 provides that there shall be levied and collected in such manner as may be prescribed duties of excise on all excisable goods other than salt which are produced or manufactured in India at the rates set forth in the schedule to the Central Excise Tariff Act 1985. It is therefore clear that as soon as the goods in question are produced or manufactured, they will be liable to payment of excise duty. Section 3 of the Act provides with the duties specified in the first schedule and the second schedule to the Central Excise Tariff Act 1985 to be levied and collected. According to it, the duties to be levied and taxes to be collected are: a duty of excise to be called the Central Value Added Tax (CENVAT) on all excisable goods, excluding goods produced or manufactured in special economic zones, which are produced or manufactured in India as and at the rates set forth in the first schedule to the Central Excise Tariff Act 1985. A special duty of excise in addition to the duty of excise specified in Clause A above on excisable goods, excluding goods produced or manufactured in special economic zones, specified in the second schedule to the Central Excise Tariff Act 1985, 5 of 1986, which are produced or manufactured in India as and at the rates set forth in the second schedule. The central government may, by notification in the official gazette, fix, for the purpose of levying the said duties, tariff values of any articles enumerated either specifically or under general headings in the first schedule and the second schedule to the Central Excise Tariff Act 1985 as chargeable. After studying this lesson, you should be able to: meaning and importance of excise tax in India, liability to pay central excise duty, levy and collection of duty, valuation of excisable goods for purposes of charging of duty of excise, remission of duty on goods found deficient in quantity, restriction on possession of excisable goods, protection of action taken under the Act. Now let's discuss CENVAT Credit Rules 2004. The CENVAT, that is Central Value Added Tax Credit, may be utilized for payment of any duty of excise on any final product, an amount equal to CENVAT credit taken on inputs if such inputs are removed as such or after being partially processed, an amount equal to the CENVAT credit taken on capital goods if such capital goods are removed as such, an amount under Sub-Rule 2 of Rule 16 of Central Excise Rules 2002, service tax on any output service. The main procedures to avail CENVAT credit are: maintaining records of inputs and capital goods, maintaining records of credit received and utilized, submit returns of details of CENVAT credit availed, principal inputs and utilization of principal inputs, returns by dealer or service provider or input service distributor. As per Section 10, transfer of CENVAT credit can be: If a manufacturer of the final products shifts his factory to another site, or the factory is transferred on account of change in ownership or on account of sale, merger, amalgamation, lease or transfer of the factory to a joint venture with the specific provision for transfer of liabilities of such factory, then the manufacturer shall be allowed to transfer the SENVAT credit lying unutilized in his accounts to such transferred, sold, merged, leased, or amalgamated factory. If a provider of output service shifts or transfers his business on account of change in ownership or on account of sale, merger, amalgamation, lease or transfer of the business to a joint venture with the specific provision for transfer of liabilities of such business, then the provider of output service shall be allowed to transfer the SENVAT credit lying unutilized in his accounts to such transferred, sold, merged, leased or amalgamated business. The transfer of the SENVAT credit under sub-rules 1 and 2 shall be allowed only if the stock of inputs as such are in process or the capital goods is also transferred along with the factory or business premises to the new site or ownership, and the inputs or capital goods on which credit has been availed of are duly accounted for to the satisfaction of the Deputy Commissioner of Central Excise, or as the case may be, the Assistant Commissioner of Central Excise. Confiscation and penalty for the Act are: if any person takes SENVAT credit in respect of input or capital goods wrongly or without taking reasonable steps to ensure that appropriate duty on the said input or capital goods has been paid as indicated in the document accompanying the input or capital goods specified in Rule 9, or contravenes any of the provisions of these rules in respect of any input or capital goods, then all such goods shall be liable to confiscation, and such person shall be liable to a penalty not exceeding the duty on the excisable goods in respect of which any contravention has been committed, or 10,000 rupees, whichever is greater. In a case where the SENVAT credit in respect of input services has been taken or utilized wrongly by reason of fraud, collusion, willful misstatement, suppression of facts, or contravention of any of the provisions of the Finance Act or of the rules made thereunder with intention to evade payment of service tax, then the provider of output service shall also be liable to pay penalty in terms of the provisions of Section 78 of the Finance Act. If any person takes SENVAT credit in respect of input services wrongly or without taking reasonable steps to ensure that appropriate service tax on the said input services has been paid as indicated in the document accompanying the input services specified in Rule 9, or contravenes any of the provisions of these rules in respect of any input service, then such person shall be liable to a penalty which may extend to an amount not exceeding 10,000 rupees. In a case where the SENVAT credit in respect of input or capital goods has been taken or utilized wrongly on account of fraud, willful misstatement, collusion or suppression of facts, or contravention of any of the provisions of the Excise Act or the rules made thereunder with the intention to evade payment of duty, then the manufacturer shall also be liable to pay penalty in terms of the provisions of Section 11 AC of the. Now let's discuss valuation of excisable goods for purposes of charging of duty of excise. Where under this Act the duty of excise is chargeable on any excisable goods with reference to value, such value shall, subject to the other provisions of this section, be deemed to be the normal price thereof, that is to say, the price at which such goods are ordinarily sold by the assessee to a buyer in the course of wholesale trade for delivery at the time and place of removal, where the buyer is not a related person and the price is the sole consideration for the sale. Where the normal price of such goods is not ascertainable for the reason that such goods are not sold, or for any other reason, the nearest ascertainable equivalent thereof determined in such manner as may be prescribed. Where, in relation to any excisable goods, the price thereof for delivery at the place of removal is not known and the value thereof is determined with reference to the price for delivery at a place other than the place of removal, the cost of transportation from the place of removal to the place of delivery shall be excluded from such price. The provisions of this section shall not apply in respect of any excisable goods for which a tariff value has been fixed under subsection 2 of section 3. Now let's discuss valuation of excisable goods with reference to retail sale price. Where the goods specified under subsection 1 are excisable goods and are chargeable to duty of excise with reference to value, then notwithstanding anything contained in section 4, such value shall be deemed to be the retail sale price declared on such goods, less such amount of abatement, if any, from such retail sale price as the central government may allow by notification in the official gazette. The central government may, for the purpose of allowing any abatement under subsection 2, take into account the amount of duty of excise, sales tax and other taxes, if any, payable on such goods. Now let's discuss remission of duty on goods found deficient in quantity. The central government may, by rules made under this section, provide for remission of duty of excise leviable on any excisable goods which due to any natural cause are found to be deficient in quantity. Any rules made under subsection 1 may, having regard to the nature of the excisable goods, or of processing or of curing thereof, the period of their storage or transit and other relevant considerations, fix the limit or limits of percentage beyond which no such remission shall be allowed, provided that different limit or limits of percentage may be fixed for different varieties of the same excisable goods, or for different areas, or for different seasons. Now let's discuss offenses and penalties. As per section 9, whoever commits any of the following offenses, namely, contravenes any of the provisions of section 8 or of a rule made under clause 3 or clause 27 of subsection 2 of section 37, evades the payment of any duty payable under this act, removes any excisable goods in contravention of any of the provisions of this act or any rule made thereunder, or in any way concerns himself with such movable, acquires possession of or in any way concerns himself in transporting, depositing, keeping, concealing, selling or purchasing, or in any other manner deals with any excisable goods which he knows or has reason to believe are liable to confiscation under this act or any rule made thereunder, fails to supply any information which he is required by rules made under this act to supply, or, unless with a reasonable belief, the burden of proving which shall be upon him that the information supplied by him is true, supplies false information, attempts to commit or abets the commission of any of the offenses mentioned in clauses A and B of this section, shall be punishable. In the case of an offense relating to any excisable goods, the duty leviable thereon under this act exceeds 1 lakh of rupees, with imprisonment for a term which may extend to 7 years and with fine, provided that in the absence of special and adequate reasons to the contrary to be recorded in the judgment of the court, such imprisonment shall not be for a term of less than 6 months. In any other case, with imprisonment for a term which may extend to 3 years, or with fine, or with both. If any person convicted of an offense under this section is again convicted of an offense under this section, then he shall be punishable for the second and for every subsequent offense with imprisonment for a term which may extend to 7 years and with fine, provided that in the absence of special and adequate reasons to the contrary to be recorded in the judgment of the court, such imprisonment shall not be for a term of less than 6 months. As per section 9A, certain offenses can be non-cognizable, notwithstanding anything contained in the Code of Criminal Procedure 1898, 4, 5 of 1898, offences under Section 9 shall be deemed to be non-cognizable within the meaning of that code. As per Section 9AA, where an offence under this Act has been committed by a company, every person who at the time of the offence was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. Provided that nothing contained in this subsection shall render any such person liable to any punishment provided in this Act, if he proves that the offence was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such offence. 9b states power of court to publish name, place of business, etc. of persons convicted under the Act. Where any person is convicted under this Act for contravention of any of the provisions thereof, it shall be competent for the court convicting the person to cause the name and place of business or residence of such person, nature of the contravention, the fact that the person has been so convicted, and such other particulars as the court may consider to be appropriate in the circumstances of the case, to be published at the expense of such person in such newspapers or in such manner as the court may direct. 9c states presumption of culpable mental state. In any prosecution for an offence under this Act which requires a culpable mental state on the part of the accused, the court shall presume the existence of such mental state, but it shall be a defence for the accused to prove the fact that he had no such mental state with respect to the act charged as an offence in that prosecution. Explanation. In this section, culpable mental state includes intention, motive, knowledge of a fact, and belief in or reason to believe a fact. 9d gives relevancy of statements under certain circumstances. A statement made and signed by a person before any central excise officer of a gazetted rank during the course of any inquiry or proceedings under this Act shall be relevant for the purpose of proving in any prosecution for an offence under this Act the truth of the fact which it contains. When the person who made the statement is dead or cannot be found or is incapable of giving evidence or is kept out of the way by the adverse party or whose presence cannot be obtained without an amount of delay or expense which under the circumstances of the case the court considers unreasonable. When the person who made the statement is examined as a witness in the case before the court and the court is of opinion that, having regard to the circumstances of the case, the statement should be admitted in evidence in the interest of justice. Now let's discuss recovery of sums due to government. 11a states recovery of duties not levied or not paid or short levied or short paid or erroneously refunded. When any duty of excise has not been levied or paid or has been short levied or short paid or erroneously refunded, a central excise officer may, within 6 months from the relevant date, serve notice on the person chargeable with the duty which has not been levied or paid or which has been short levied or short paid or to whom the refund has erroneously been made, requiring him to show cause why he should not pay the amount specified in the notice. The central excise officer shall, after considering the representation, if any, made by the person on whom notice is served under subsection 1, determine the amount of duty of excise due from such person not being in excess of the amount specified in the notice, and thereupon such person shall pay the amount so determined. Section 11b states claim for refund of duty. Any person claiming refund of any duty of excise may make an application for refund of such duty to the Assistant Collector of Central Excise before the expiry of 6 months from the relevant date, in such form as may be prescribed, and the application shall be accompanied by such documentary or other evidence, including the documents referred to in Section 12a, as the applicant may furnish to establish that the amount of duty of excise in relation to which such refund is claimed was collected from or paid by him and the incidence of such duty had not been passed on by him to any other person. If on receipt of such application the Assistant Collector of Central Excise is satisfied that the whole or any part of the duty of excise paid by the applicant is refundable, he may make an order accordingly and the amount so determined shall be credited to the fund. Notwithstanding anything to the contrary contained in any judgment, decree, order, or direction of the appellate tribunal or any court in any other provision of this Act or the rules made thereunder or any other law for the time being in force, no refund shall be made except as provided in subsection 2. Section 11C states power not to recover duty of excise not levied or short levied as a result of general practice. Where any notification under subsection 1 in respect of any goods has been issued, the whole of the duty of excise paid on such goods, or, as the case may be, the duty of excise paid in excess of that payable on such goods, which would not have been paid if the said notification had been in force, shall be dealt with in accordance in force, shall be dealt with in accordance with the provisions of subsection 2 of section 11b. 11d states duties of excise collected from the buyer to be deposited with the central government. Notwithstanding anything to the contrary contained in any order or direction of the appellate tribunal or any court or in any other provision of this Act or the rules made thereunder, every person who has collected any amount from the buyer of any goods in any manner as representing duty of excise shall forthwith pay the amount so collected to the credit of the central government. Now let's discuss protection of action taken under the Act. Section 40 of the Act prescribes the protection of action taken under the Act. No suit, prosecution, or other legal proceeding shall lie against the central government or any officer of the central government or a state government for anything which is done or intended to be done in good faith in pursuance of this Act or any rule made thereunder. No proceeding other than a suit shall be commenced against the central government or any officer of the central government or a state government for anything done or purported to have been done in pursuance of this Act or any rule made thereunder, without giving the central government or such officer a month's previous notice in writing of the intended proceedings and of the cause thereof, or after the expiration of 3 months from the accrual of such clause. Now let us check if we have understood the various concepts discussed in this lesson clearly. As per section 9a, certain offences can be non-cognizable notwithstanding anything contained in the Code of Criminal Procedure. Right or wrong? Right. Central excise duty is an indirect tax levied on those goods which are manufactured in both India and outside India and are meant for home consumption. Right or wrong? Wrong. CENVAT, that is Central Value Added Tax, may be utilized for payment of any duty of excise on any final product. Right or wrong? Right. Now let's revise what we have studied till now. Excise duty is an indirect tax levied on those goods which are manufactured in India and are meant for home consumption. The taxable event is manufacture, and the liability of central excise duty arises as soon as the goods are manufactured. It is a tax on manufacturing which is paid by a manufacturer who passes its incidence on to the customers. The term excisable goods means the goods which are specified in the first schedule and the second schedule to the Central Excise Tariff Act 1985 as being subject to a duty of excise and includes salt. As incidence of excise duty arises on production or manufacture of goods, the law does not require the sale of goods from place of manufacture as a mandatory requirement. Normally, duty is payable on removal of goods. The Central Excise Rules provide that every person who produces or manufactures any excisable goods or who stores such goods in a warehouse shall pay the duty leviable on such goods in the manner provided in rules or under any other law. No excisable goods on which any duty is payable shall be removed without payment of duty from any place where they are produced or manufactured, or from a warehouse unless otherwise provided. The word removal may be for sale, transfer to depot, captive consumption, transfer to another unit, or free distribution. Thus, it can be seen that duty becomes payable irrespective of whether the removal is for sale or for some other purpose.